Amid complaints over price surges and exorbitant fares, ride-sharing firm Grab, the dominant player in the local market, is looking to increase its rates even further. In fact, it has a pending petition to jack up its current per-kilometer rate from 10 to 14 pesos to 11 to 15 pesos. So today, our two teams will debate on the legality of Grab's pending price increase and whether or not the move is necessary, beneficial, or practicable in the first place. Hello, I'm Maiki Oreta, and you're watching Square Off, Season 15, The Firm Debates.
Transport network vehicles follow the law of supply and demand. When supply is low and demand is high, prices shoot up. But what happens when the commuting public starts to feel abused?
Dati kasi parang mga 220, parang 270 na pag umuwi ako pag umaga. Wala na eh, yun na eh. So sakay ka na lang.
Kung dati-rati kasi yan eh, kapag nag-start lang with 40, gano'n. Ngayon kasi may dagdag.
The management of Grab Philippines explains, with just 35,000 TNVs on the road and 600,000 rides per day, it is easy to see why the surge has to kick in.
About 6,000 of them onboarded quickly because what's causing the surge is the massive increase in the demand but the reduced supply. So it's something we're working with LTFRB on. Unless you're on the list, you cannot drive. So we know who these drivers are, but we cannot onboard them until we get a go signal.
Last month, the Land Transportation Franchising and Regulatory Board mandated Grab to lower their surge pricing cap from ×2 to 1.5.
Magbabawas na naman ang kita sa amin, especially sa rush hour.
This is to ensure that the fares will be at a rate that is conducive.
So, is Grab's imposition of increased fares illegal?
Arguing for the affirmative side is the University of the Philippines. Imbued with honor and excellence, the next generation of lawyers from the University of the Philippines.
I think debating for me is a lifestyle, so it consists of knowing the current issues, being aware of those issues, and trying to understand both the arguments for and against particular policies and particular viewpoints. Debate is one of the ways in which we understand and communicate with others, as well as try and make sense of how we govern ourselves as a country.
Debating for me is a way to confront ideas that may be sensitive, may be controversial, but to confront it in a way that's civilized and that shows respect for other people who might hold different views.
For me, debating is discourse. It's learning, studying different sides of an issue and arguing for them.
Team University of the Philippines. Sharp, fierce, diverse. Taking on the negative side is the University of Batangas. From the university in pursuit of knowledge, values, and skills, the next generation lawyers from the University of Batangas.
Debating for me is more than just a clash of minds. It is a method, a means by which we can bring into light the issues of our nation. It is, for me, it is a way of information dissemination, an effective means to combat fake news.
Debating is stressful, but debating is a means for us to channel our inner lawyers, even though we are still law students. And debating prepares us from actual law practice because the preparation inherent in debating is not a joking matter. It is something to be proud of for you to prepare for a big event like this.
debating for me is a platform to be able to hear opposing sides about socially relevant issues. It's being able to air out grievances without hostilities and with due regard to scholarly research.
Team University of Batangas. Spirited, intellectual, tenacious. Let's now meet our distinguished judges. First off, we have attorney Maria Concepcion Simundak, a partner at the VNA law firm. Next, we have attorney Ferdinand Cases. He is a professor at the Ateneo School of Law. He's also a member of the Philippine Judicial Academy and Center for Global Best Practices. And presiding as our chief adjudicator is Judge Princess Bustos Onqueco from the Regional Trial Court, Branch 91 in Santa Cruz, Laguna. We're using a modified Oregon-Oxford format. The debate is between two sides, the affirmative and the negative, with 3 members each. Each debater from the affirmative side argues the necessity, beneficiality, and practicability of the proposition, while the counterpart debaters on the negative side oppose these arguments. Each debater is given 4 minutes to deliver a constructive speech and rebut the previous argument. Each debater is given 2 minutes to interpolate or cross-examine the opposing debater. Only categorical questions may be asked. Each of the judges may ask 1 question of each speaker within that speaker's time limit. The judges score each team in terms of manner, matter, and interpolation. The team with a higher score from each judge gets a point. The team with the most number of points wins the debate. The chief adjudicator rules in the event of ties, objections, or contestations. This week's proposition, let it be resolved that Grab's imposition of increased fares is illegal. Starting off for the affirmative side, we have Tanya. Tanya, you've got 4 minutes to tell us why Grab's increased rate scheme is illegal.
Your Honors, ladies and gentlemen, it is a paramount duty of the state to safeguard public welfare against the predatory practices of businesses engaged in the provision of public services. Today, I will argue that Grab's unauthorized increase in fare is illegal because it violates at least 2 laws. First, the Commonwealth Act 149, or the Public Service Act, and second, Executive Order 202, otherwise known as an act creating the LTFRB. Section 20 of the Public Service Act, as amended, provides that it's unlawful for any public service provider, for any public service owner, operator, or lessee to impose, collect, or carry into effect any rates, fares, or charges without the approval or authorization of the LTFRB. The purpose of this law is to ensure that public service providers do not take advantage of their position to the prejudice of the general public who are in need of their services. The coverage of the Public Service Act extends to all public utility vehicles, and because the Department of Transportation and Communication classified transportation network companies such as Grab as public utility vehicles, then it is legally bound to comply with the Public Service Act. However, it is clear from the facts that Grab implemented additional charges without the authorization of the LTFRB. In fact, on April 11, 2018, LTFRB issued a show-cause order directing Grab to explain why it should not be suspended for implementing additional charges and collecting them without the authorization of the board. Clearly, by imposing these additional charges, Grab violated Section 20 of the Public Service Act. Furthermore, Your Honors, Grab also violated Executive Order 202, particularly...
Yes, Ms. Speaker,
Yes,
isn't it under DO 2015-11, TNCs are specifically allowed to impose their own fees?
Thank you, Your Honor. The spring cannot rise higher than its source. Given this DO, even if it allows TNCs such as Grab to set their own rates, we cannot discount the fact, or we cannot dispense with the requirement of authorization as imposed by the Public Service Act, which is higher in the hierarchy of laws because it is a legislative enactment. If I may proceed, Your Honors. Now, Grab also violated Executive Order 202, which grants the power to LTFRB to regulate its prices. In the exercise of these regulatory powers, the LTFRB actually, on December 27, 2016, issued an order stating or directing Grab to maintain its fares at 10 to 14 pesos per kilometer. It is elementary that administrative issuances have the force of law and are entitled to great respect. But Grab violated this order, this LTFRB order, when it imposed the unauthorized 2 peso per minute charge. Yes, Your
If you disallow Grab from increasing its fares, would this not be in violation of unjust enrichment?
Thank you, Your Honor. We don't think that it is a violation of unjust enrichment. As we have learned in the case of Pagadian versus Republic, public utility vehicles or public services in general are actually not property rights, for example. They are grants or privileges from the state. Therefore, the state has every power to regulate the businesses of public utility vehicles and other public service providers. If I may proceed, Your Honor. Now, Grab's violation of the LTFRB order, we believe that it is also done in bad faith because Grab knows that it cannot adjust its prices without authority from the LTFRB. Several instances prove this point. First, when the LTFRB imposed a cap on its surge pricing back in 2017, Grab complied until its petition to lift the cap was approved. Second, when it wanted... Thank you, Your Honor.
2 minutes for the cross-examination.
Good day, ma'am.
Good day.
The basis for your arguments are LTFRB and DOTR issuances, am I correct?
Yes, also CA 146.
Is Grab under the jurisdiction of the LTFRB, ma'am?
Yes, clearly.
As a common carrier?
Yes, it is.
Does Grab actually carry passengers, ma'am?
Yes, it does, definitely.
No, ma'am. Grab as a TNC, does it carry passengers, ma'am?
Yes, it does. Already in the findings of
LTFRB memorandum circulars and the DOTR issuances have already differentiated TNCs as a company from TNVS as the drivers.
Are you aware, Mr. Speaker, that Grab actually owns and operates cars? Therefore, it falls within the definition
yes,
of a
as a TNVS, ma'am, but as a TNC, it does not actually carry passengers.
But does the motion differentiate between
ma'am,
the two?
does the travel agency actually carry passengers?
No, it does not.
Because the business scheme of a Grab and travel agencies is in connection with the connection of passengers with their actual carriers. Am I correct?
I'm sorry, can you please?
The business scheme of Grab and travel agencies is the connection between a passenger and the carrier. Am I correct?
I'm sorry, your question is very vague.
The business scheme of Grab and travel agencies is the connection of a carrier to its passengers.
Of course not, because Grab also provides transportation services.
As a transport network company, ma'am, it merely connects passengers to their carriers.
No, it's already established in the DO that there's an employer-employee
Have you read, ma'am, the case of Crisostomo versus Court of Appeals?
Enlighten me, please.
In that case, a business engaged merely in the connection of carriers to its passengers without doing any actual carriage can set its own fares, and such fares would be beyond the power of review of any administrative body.
But this is irrelevant to Grab.
Ma'am, in the absence of laws and court decisions, can we rely on decided cases?
We can, of course, but there are laws.
Is there a law or court which decides definitely and categorically?
All right, Denji, you've got 4 minutes now to rebut Tanya and advance your argument on why Grab's increased rate scheme is illegal.
Your Honor, some points of rebuttal before I proceed to my constructive. In the case of North Negros Sugar Company versus Hidalgo, it was held that the declaration of whether or not an entity is a public utility or a common carrier is a judicial question. It cannot be determined by the LTFRB sitting as an administrative agency. Moreover, the doctrine of operative facts states that the rights and acts which are relied upon by persons in good faith subsequently voided must have to be recognized as valid. In this case, even if we assume that Department Order 2015-11 is void, the imposition is still legal. Another point is that there is no retroactivity of laws in this case because Article 4 of the Civil Code states laws shall not have retroactive effect unless the contrary is provided. Nowhere in Department Order 2017-11 was it stated that it can be applied retroactively. Your Honors, let me proceed to my constructive. It is the negative side's contention that the imposition of increased fare prices by Grab as a transport network company is legal. We explained the nature of the business of Grab. We clarified that Grab as a TNC is different from its Grab drivers as TNVS, which are the Transport Network Vehicle Services. There are three parties involved in Grab's usual conduct of business: Grab as a TNC, the drivers as the TNVS, and the passengers. From here, we can clearly see that Grab as a company is different from its drivers. Three contracts are formed: an ordinary contract between a TNC, which connects the passenger to the TNVS, a contract of carriage between the TNVS and the passenger, and a service contract when the TNC provides to the TNVS an online platform by which it is connected to its passengers. Now, the nature of business of Grab is akin to that of a travel agency. Three contacts are also formed when a travel agency provides a platform to connect the airline to its prospective passengers. Number 1, an ordinary contract. Number 2, a contract of carriage. And number 3, a service contract. These are exactly the three contracts formed when a TNC provides the TNVS an online platform to meet its passengers. In the case of Crisostomo versus Court of Appeals, the court held that a travel agency's service is limited to facilitating pre-arranged passengers' bookings, and this is the same as the purpose of the TNC, as the functions of the TNC. It merely facilitates the connection between the passengers and the TNVS, and this function is provided and declared by the LTFRB itself. Being a private enterprise the same as a travel agency, it must necessarily have the freedom to contract and the freedom to set its own prices. Another compelling case, Your Honors, is that of Iloilo ICE versus Public Utility Board. In this case, there was a taxicab business engaged in the business of furnishing automobiles from its central garage based on special individual orders placed by telephone. The court held that such business setup is based on special individual orders, and therefore it has the freedom to set its own fares, it has the freedom to contract, and the fares it will set is outside the jurisdiction of the then Public Utility Board. Grab's services, Your Honors, are exactly the same as that in the taxicab business in this case, and the only difference is that in hailing rides, the business of the taxicab in this case uses the telephone, and in case of Grab, it uses an internet-based platform. As such, the prices set by Grab must also necessarily...
2 minutes for the cross-examination.
Good day, Mr. Speaker.
Good day, ma'am.
Are you aware that Department Order of the OTC, Department Order 2015-11, already classified Grab as a public utility vehicle?
It is outside the jurisdiction to do so.
You're saying that, but it's already a fact. Don't you know that administrative issuances, Mr. Speaker, enjoy the presumption of regularity?
Yes, ma'am.
Yes. Therefore, until this DO is revoked, Grab remains a public utility vehicle, and all applicable laws on PUVs are also applicable to Grab. Am I correct?
No, ma'am. The presumption of regularity does not apply to void acts, ma'am.
Thank you, Mr. Speaker. You were arguing earlier that Grab has the right to contract. Am I correct?
Yes, ma'am.
But do you know that the right to contract is not absolute and must yield to public welfare?
Yes, ma'am.
Yes. But do you know that Grab's franchise is not even a contract in the sense of the contract in the Constitution, because it is a grant or a privilege given by the state to the one operating the public service?
No, ma'am. The contract here is between the passenger and the TNVS as facilitated by Grab.
Thank you, Mr. Speaker. So you are arguing that Grab can set prices as high as they can?
Yes, ma'am. Subject
really
only to reasonable limitations as provided by law, ma'am.
Are you aware, Mr. Speaker, that Grab filed a petition last January 2018 requesting for a fare hike because of the implementation of train?
Yes, ma'am.
So why does it have to file a petition if it doesn't need the approval of the LTFRB?
Because the LTFRB...
Don't you think that it's already admitting the jurisdiction and the authority of the LTFRB to approve its fare pricing?
No, ma'am. It's submitted to the jurisdiction of the LTFRB as a TNC just to comply with their requirements. But
So you're admitting, therefore, that it is under the regulation of the LTFRB?
No, ma'am.
But you said they have to comply with the requirements of
They chose to comply, ma'am.
Thank you. Are you aware, Mr. Speaker, that the website of Grab itself says...
Second affirmative, Speaker Bass, you've got 4 minutes to tell us why it would be beneficial to prohibit ride-hailing firm Grab from increasing its fares.
Thank you. Good afternoon. Before I go on to my arguments, 4 points of rebuttal for the previous speaker. His entire point centers around the assumption that Grab is not a public utility company and it's likened to a private contract between the passenger and the TNVS. 4 points of rebuttal. First, there's already DO 2015 that explicitly says that TNVSs are public utilities under the jurisdiction of the LTFRB, and there has to be a presumption of regularity there. Secondly, there's also an acknowledgement from Grab that they are under the jurisdiction of the LTFRB, and that's why they go through the processes of applying for franchises and for licenses. Thirdly, Grab also participated in proceedings and hearings, and they actually subscribed to the LTFRB order. Number one, lowering their fare from to 11 to 14 pesos, and number two, lowering their surge prices from 2 times to 1.5. So if they do reject or impugn the jurisdiction, why is it that they actually subscribe to these processes and these proceedings to begin with? But fourthly, there's also a principled inconsistency, because later on in his speech, he says that, well, there's freedom to contract, but later on he said it's still subject to reasonable limitations under the law. So he really fails to set a clear standard as to how absolute this freedom to contract is. So I want to go on to my argument about how considering arbitrary price hikes illegal actually benefits both the riding public and TNC drivers. What we have to characterize is that Grab operates in an industry that is imbued with public interest. That is because the service that they provide is indispensable to people's daily affairs, and therefore it is actually a lawful subject for police power that fits the standard as mentioned in the case of Planters Products v. Fertifil Corp. We think that the state has an interest in regulating Grab because there are incentives for utilities, for transport utilities at times, to prioritize profit over people. We think preventing arbitrary price hikes has 3 particular economic benefits. First, we lessen the economic burden of passengers from having to pay exorbitant fees. And this comes in the context where, number one, there are market imbalances, such as the monopolies in these industries and the excise tax that already financially constrain and create heavy burden on the riding public. We think arbitrary price increases from Grab actually increase that burden even further, and an order of illegality or a consideration of illegality actually provides economic benefits for these passengers. Secondly, we also uphold the legal requirements of due notice and hearing and forward transparency. We think in this context, Brian Koo, who was the head of Grab, openly admitted that the proposal for the 2 pesos time increase was only passed upon in the technical working group, but was not really proposed even further to the LTFRB board. We think that this violates the very standard of due notice and hearing, especially when regulating price hikes, because what we have to characterize is that the power of the LTFRB to actually regulate and determine price hikes, because it's a specific case, is a quasi-judicial power. And therefore, we have to afford people the right to due notice and hearing. We think a consideration of illegality sets the precedence and actually increases the chances for more participation in the future to uphold due notice and hearing standards. But thirdly, we also benefit drivers as well, because the effect of arbitrary price hikes is that passengers are more likely to rely on other alternative modes of transportation which are consistent and predictable. When that happens, there's less of an incentive for them to actually rely on Grab as a service. That detriments drivers as well, because there's lesser supply for their services. There's lesser supply for the kinds of things that they can provide under Grab. Ultimately, what illegality provides is the incentive for Grab to actually prevent or to not have arbitrary price increases in the future. Because if they do so, they will be subject to, number one, possible revocation of the licenses and franchises, or to possible penalties as well.
2 minutes for the cross-examination.
Good afternoon, Mr. Speaker.
Good afternoon.
I assume that you have read very well DO's 2015-11.
Yes, we read it very well.
It defined TNCs and their functions, correct?
Yes, it did.
It stated therein that the functions of TNCs are to facilitate the pre-arranged travel agreements between drivers and the passengers, correct?
Yes, but under that same deal as well,
proceed,
it actually
does
the
Grab
TNCs under
actually
jurisdiction.
carry out the contract of carriage?
It is a contract, but it is still subjected to the regulation of the LTFRB.
Does Grab actually undertakes the contract of carriage?
It does,
no,
but it is also heavily regulated.
It only provides the platform to connect TNVS drivers.
Sir, it is the explicit wording of the law, so we have to.
What law? Are you talking about CA 146?
CA 146
stated therein that public utilities. It
2011-15.
stated therein that public utilities are required to secure certificate of public convenience and necessity. Correct?
Yes.
Have you read Memorandum Circular 2016-011 of LTFRB?
Yes.
It stated therein that TNC's accreditation do not require them to have a certificate of public convenience. Thus, they do not fall within the ambit of CA 146. You're misleading the.
We have to resolve CA 146 with these GOs at the same time. Plus, there's already an
no further
acknowledgement.
cross, Your Honors.
Nico, you've got 4 minutes now to rebut Bass and advance your argument on why Grab's price hike is indeed beneficial.
Your Honors, ladies and gentlemen, good afternoon. Just point of rebuttal before I proceed with my constructive. I invite your attention to the case of JG Summit Holdings versus Court of Appeals. In that case, Your Honors, public use was differentiated for public interest. Public utilities, yes, are indeed synonymous with public use because its main indicia is that it can be demanded by the public as a matter of right. Public interest, Your Honors, as the case of Grab, only concerns transportation, but not necessarily their services are limited to the clientele, to their clients that book services at Grab who has Grab application. They are privileged individuals who have internet connection and mobile data. They cannot ride-hail the public. Yes, Your Honor.
Are you saying that Grab should not be regulated by the LTFRB and should not be issued certificates of public convenience?
Thank you for that, Your Honor. Your Honors, we submit that the state can exercise its police power. However, the exercise of police power by the state does not necessarily mean that it will avoid a valid legal act previously relied upon by Grab in the of 2015-011. Proceeding now with my constructive, Your Honors, the private sector has an indispensable role to play in the realization of the social justice policies of the state. On that note, Your Honors, the University of Batangas wishes to impress upon the forum that the imposition of increased fair price of Grab is legal on 2 points. It has the right to, first, Grab has the business prerogative to impose this increased fair price. It has the right to expect a reasonable rate of profit from business operations commensurate to the risk assumed and capital involved, and of course, consistent with existing laws. To clarify the premise, Your Honors, in Southern Luzon versus DSWD, the court emphasized that the law does not place a cap on the amount of markup that covered enterprises may impose on its services. This is because rates should enable operators to generate revenue sufficient to cover their operational costs and provide reasonable return on investments as explained in KMU versus Garcia. From the foregoing, Your Honors, we must look into the rationale of the imposition of the fare increase. In April 17, 2018, Grab reasoned out that the purpose behind such is to enable drivers to cope up with the rising prices of commodities. Your Honors, that is a laudable rationale considering that 80% of the fare inures to the benefit of the drivers. After all, the court in Viloria versus Continental Airlines held that Continental has the exclusive prerogative to fix the prices of its services and may not be compelled to observe and maintain the prices of others similarly situated. This leads me now to my second point. The imposition is an exercise of freedom to contract. It appears now beyond question that what governs between the TNCs and the riding public is that of an ordinary contract for services as discussed in the case of Crisostomo versus Court of Appeals. The passenger, in availing the services of Grab in order to be linked with a third-party driver, communicates his acceptance of the offer after consenting to the price set by Grab through confirmation of the booking. A contract is then born, becoming the law between the parties. It is valid considering that neither law, nor public policy, nor public order was violated. Your Honors, freedom to contract is a constitutional and statutory right as enunciated in Moria versus Belmonte. This has been established as early as 1941 in the case of Gabriel versus Monte de Piedad. In the present predicament, Grab's freedom to contract is actually recognized by the state in DO 2015-011 when it allowed Grab to set its own fare prices for the TNVS. Therein, to close, Your Honors, the Philippine legal framework cannot countenance an interpretation that undermines a stipulation freely and validly agreed upon. I'm now ready, Your Honors, for my interpretation.
2 minutes for the cross-examination.
Thank you. Good afternoon, Mr. Speaker.
Yes, Mr. Speaker.
Are you aware of CA 146?
Yes, I'm very much aware.
So CA 146 is the law that creates LTFRB.
Yes, it requires certificate of public convenience.
Yes, is CA 146 limited to regulating only public utility vehicles?
Also public service vehicles, yes.
Public service vehicles. Yes. So assuming
public
that Grab is, assuming but not conceding that Grab is not a public utility vehicle, it would still fall under the regulation and jurisdiction of CA 146.
No, it does not have a certificate of public convenience.
Does Grab own its own cars?
No,
and operates?
It connects drivers and passengers. It does not own their own cars.
It actually does own its own cars, and there's already matter for that. Are you aware that Grab has already intended to comply with all LTFRB regulations?
Yeah, that's their good faith in consenting to the law, because right now there is no regulation regulating TNCs.
Are you also aware that they've already complied with the 10 to 14 price increase? And also the 1.5 surge limiting their rates.
Yes, thus the surge is not illegal, considering that they complied with the valid law. That's
so.
legal.
Therefore, that actually proves that there's a presumption of regularity, and in fact, there's a legitimacy of LTFRB to prescribe these rates. Because if otherwise, then why would Grab actually subscribe to them?
Because Grab has a public service aspect in the sense that they must assure public safety. But as regards fare, they are not public utilities in the first place. Memorandum Circular 2015.
They are public utilities. Do you think that the plain wording of the law has to be interpreted?
Yes.
So DO 2011-15 already explicitly categorized them as public utility vehicles. Are you undermining the plain wording of the law?
No, considering that under North Negros Central Sugar Company versus Hidalgo,
so between the plain construction
are subject to judicial determination.
So between the plain construction of the law and your interpretation of a private carrier with no jurisprudential basis, I'm sorry, Mr. Speaker, it's actually my time. It's actually my time. So between the plain construction of the law and your conception.
Okay, time now for the third affirmative speaker. Angela, you've got 4 minutes to tell us why Grab's imposition of higher fares is both illegal and not practicable.
Your Honors, good evening. As someone who commutes 3 to 4 hours a day, I can say that Grab's increased price has largely disincentivized riders. But I shall also argue that increased price is illegal and it is not practicable and feasible because otherwise there would be negative ramifications. First, regulatory problems for the LTFRB, and second, business problems for partner drivers using Grab. But before that, a few responses to the negative case. The first response is that the premise of negative is to claim that TNCs are not common carriers because they don't carry passengers and therefore they're not within the jurisdiction of the LTFRB. However, this argument is misplaced. In the case of Eastern Assurance versus LTFRB, the power of the LTFRB to regulate public utility vehicle insurance companies was upheld by that court. Insurance companies, similar to travel agencies, don't carry passengers, but that does not mean that these are not within the LTFRB jurisdiction. Therefore, on a second point, we would say as well that the argument of negative side in second negative that DO 2015 applies does not in fact change the stance of affirmative. The provision that allows TNCs to set fares does not change the requirement of LTFRB approval. The DO itself says that fares are subject to LTFRB oversight in cases of abnormal disruptions of the market. The actual change or disruption here is the fact that Grab has now a monopoly. And the imminent change in the market is the fact that there are now entrants or new TNCs being accredited by the LTFRB. In any case, the LTFRB is authorized to fix final fares under the public service law, and the DO cannot supersede that requirement. On the third response, we would say that operative fact doctrine as argued by negative does not apply to the current actions and only to past actions, and it cannot justify the continued imposition by Grab of illegal fares. On a last point, the increased fare petition for train is improper given the unresolved issue of the 2 pesos time duration charge. To increase a fare, there must be an already set fare to increase. Therefore, given that we have debunked the negative side, I shall now argue my first submission. It is that legally allowing TNC set fares would make the LTFRB toothless. This because the case of Grab would now be invoked as precedent against the interference or the rate fixing power of the LTFRB. This will cause 2 outcomes: arbitrary fares and arbitrary rules. On arbitrary fare, we say that in the aforementioned case, even cited by negative KMU versus Garcia, transport operators were disallowed from setting their own fares precisely because it practice the LTFRB's government function to assess a just and reasonable rate. On arbitrary rules, we would say that now LTFRB has to decide on a case-to-case basis. This is because Grab's pricing unilaterally creates an uneven playing field for other public transport services. The same standard of notice and hearing for approval of fare schemes must apply as well to TNCs. Otherwise, the case-to-case basis will hinder the LTFRB from standardizing rules for the regulation of the public transport system. For negative side to imply that the TNCs will not be under any regulation is an absurd an absurd situation or an absurd way to construe DO 2015-11. Yes, Your Honor.
Granting that the other side, the negative, says that Grab does not need a certificate of public convenience and need not be under the LTFRB. If you say that it needs to be under the LTFRB, if the LTFRB would just ease up on Grab, wouldn't the natural laws of supply and demand just take over? Because if you regulate the prices of the ones under the LTFRB, therefore the public would go to you and not to Grab. Wouldn't that be the case?
We would say that there's a disruption, considering that the LTFRB must regulate on a
Sorry, we don't have time
TNCs.
for that answer. 2 minutes now for the cross-examination.
Good evening, Madam Speaker.
Good evening.
It is in your speech that there was no notice and hearing. That's why the imposition is illegal. That's correct.
Yes,
and necessarily, it is a public utility before they could be required for that notice and hearing. Now, I am sure you are aware of the difference between TNC and TNVS, though the prior speaker seem not to know that. You know that. Let's go to the concept of common carriers. Just yes or no, Madam?
Yes.
The test to determine whether or not a courier is a common carrier is if the public can demand its services as a matter of right or merely privilege, correct?
Yes.
Correct. That's the consistent ruling of the court, such as in Spouses Chodoro versus Nicolas. When you say you have a right, Madam, you can actually demand from others the performance of a specific task, right?
Yes, that's right.
When you use Grab arranges your ride, where to drive, and when to drive, correct?
Yes, that's right.
There are instances when the drivers actually decline, correct?
Yes, that's right.
Yes, that's correct. If a Grab driver declined, can you sue him as a statutory right or at least demand from him to take you to your destination no matter what?
I will
of
have
course
a right
not,
for
Mrs.
damages
Speaker,
and
because
other
it's
sorts
only
of
a privilege covered by an ordinary contract. Let's proceed. What is the document evincing that an entity is a public utility? CPC, right?
Yes, that's
right. Do you know what kind of certificate did LTFRB issue to Grab? Is it a CPC?
No, it's not.
No, it's not, because it's a certificate of accreditation.
But
Do you
we've
know
already
that there's a
argued.
difference between a CPC and a certificate of accreditation,
Yes,
Mr. Speaker?
that's right.
Then it follows that LTFRB itself does not recognize TNC as a public utility, Your Honors. Continuing, Mr. Speaker, do you know Section 5 EO number 202 creating the LTFRB?
Of course.
Section 5 thereof enumerated 13 powers. Are you aware of them?
Yes, of course.
Section 5C
Yes.
as the regulation of fares. But do you know that it only applies to public land transportation services? Do you know the meaning of a public land transportation service?
I disagree with their premise,
No.
counsel.
Do you know the meaning of
Yes,
public
I do
land?
know the
In
meaning.
the case of Lump versus Meralco, it says it's public utility.
Okay, Benjo, you've got 4 minutes now to rebut Angela and advance your argument on why Grab's imposition of higher fares is actually practicable.
Your Honors, good evening. Before I proceed with my rebuttals, I just have to point out an interesting observation to what the affirmative bench is espousing. It seems that the opposite side is under the impression that since Grab appears to behave as a public utility, it is a public utility. But this, Your Honors, is a flawed exercise of abductive reasoning, essentially arguing that if it looks like a duck, walks like a duck, and quacks like a duck, it is a duck. It completely discounts the possibility that it may be a chicken impersonating a duck for fear of undue sanction from LTFRB. Now, on to my rebuttals, Your Honors. They would say that LTFRB considered TNC as a public utility. That, Your Honors, is a lie because it only issued certificate of accreditation, not of CPC. Also, they would say, Your Honors, that Public Service Act is violated in this case. That is not the case, Your Honor, because again, Grab is not a common carrier within the contemplation of such law. In the case of, yes, Your Honors.
Would it not constitute unfair competition that one transport service that services the public would be subject to the LTFRB and the other not?
Not necessarily, Your Honors, because TNC is covered by the Philippine competition law, and in this case, we say that the same is not a violation of Philippine competition law. Continuing, Your Honors. In the case of Negros Sugar Company versus Hidalgo, a legislature cannot, by mere regulatory order, convert a private business into a public utility. And the question whether or not a particular company or service is a public utility is again a judicial one. Hence, in the absence of any decision classifying Grab as public utility within CA 146, we must revert back to the prevailing jurisprudence. In JG Summit versus CA, if the use is merely optional with the owners or the public benefits is merely incidental, it is not a public use, and this does not legally authorize the exercise of jurisdiction of the then Public Utility Commission, now LTFRB, under EO number 202. In the case of Grab, it is not for... Yes, Your Honor.
You're of the position that TNCs are not public utilities,
yes,
right?
Your Honor.
So how about the TNVS?
TNVS, Your Honors, currently it's treated as a common carrier, though we do not concede on that, and we want to revert back to the issue at bar, which is that of a TNC, which we consider not as a common carrier, Your Honors. In the case of Grab, it is not for public use, but merely one of public interest. Then the regulation cannot justify its classification as a public utility. Hence, the TNCs are not covered by the Public Service Act, and therefore, such law is not violated, which leads me to my constructive. Your Honors, we want to dispel any and all doubts as to legality of the imposition of the increased fare of Grab on two grounds. First, LTFRB has no power to regulate fare of Grab, as it is an invalid expansion of the law by the administrative agency. And second, not a single law is violated by such imposition. Section 5, EO 202, Your Honors, gives the power of LTFRB. Section 5C thereof provides for the power to determine, prescribe, and approve fares, rates, and charges, but only as regards public land transportation service, which, according to the case of Lump versus Meralco, pertains to public utility. Simply put, Your Honors, in transportation industry, LTFRB has the authority over common carriers only. In the case of Lump, again, Your Honors, only public utility submits to the regulation of government authorities and surrenders certain business prerogatives, including the amount of rates that may be charged by it. The same clearly does not apply to a non-public utility such as Grab. After all, the power of administrative officials is necessarily limited to what is found in the legislative enactment itself. In Grande versus Antonio, the law cannot be broadened by a mere administrative issuance, as administrative agency certainly cannot amend an act of Congress. Your Honors, at this point in time, today it is like fake news to the general public to rule that the imposition of increased fare is not legal, consistent with laws and jurisprudence. Your Honors, it is legal. Thank you, Your Honors. Now ready for my cross.
2 minutes now for the cross-examination.
Good evening, Counsel.
Good evening.
It is your position that the LTFRB can only regulate common carriers, yes?
They can also regulate,
yes,
but not as to charges.
So you have not read the case of Eastern Assurance versus LTFRB.
Enlighten me, Mrs. Speaker.
In that case, the LTFRB was allowed the power to regulate insurance companies of public utility vehicles.
Regulations, but
Our
not
insurance
as to charges,
companies,
Mrs. Speaker.
Counsel, I don't want to have a shouting match with you. So I would like to ask, are insurance companies common carriers?
No.
And yet, the LTFRB can regulate them. So we see that that basis is not actually applicable. Have you read Section 11, Article 12 of the Constitution?
Yes.
So you are aware of the state power to regulate monopolies?
Yes, Madam.
So you therefore are aware that the Eastern Assurance also said that LTFRB can exercise that state power?
Yes, but not as to charges. Again,
understood. Let's move towards a different line of argumentation.
Legality of charges.
All right, Counsel. So you agree that TNVs are regulated by the LTFRB?
Yes.
Yes. All right. So is it true that the 2 pesos per minute charge is actually goes to the benefit of these drivers?
Not the NBS.
Yes or no,
Let's
Counsel?
not mislead the public, Mr. Speaker.
Mr. Speaker, is it true that the 2 pesos charge goes to Grab drivers?
80%
yes,
of which? 80%.
So therefore, you are agreeing that part of this fee and this charge regulated by LTFRB goes to individuals that are regulated by the
prerogative,
LTFRB.
Mrs. Speaker.
And therefore, we would say that therefore there is some level of allowable regulation by the LTFRB,
yes, there
which
is.
you have not argued.
There is.
Counsel, are you aware that that LTFRB Chair Delgra said that Grab did not disclose its fare matrix?
Come again? That's because under DO 2015-11 they are required without authority of the LTFRB, Your Honors.
So are you aware, Counsel, that Grab's country head himself admits that there was no disclosure of the charges?
Because that's not needed under DO 2015.
Thank you, Counsel.
Let's now hear what our judges have to say about our debaters. Attorney Simundak, how did the affirmative side, the University of the Philippines, do?
Congratulations, team. It was a very good presentation. I like the fact that your position was consistent and coherent all throughout, and you knew when to supplement and to strengthen the arguments of your teammates. Thank you.
And Attorney Cases, it's difficult to gun for higher fares, but how did the negative side, the University of Batangas, do?
Well, they presented well-researched arguments based on what the law provides, as well as the current jurisprudence.
And now let's hear from our chief adjudicator, Judge Onqueco. Your Honor, who did the judges pick for best speaker?
You know, personally, I think that if there's only one thing that you learn from going to law school, you must learn the ability to speak well. Different judges had different favorite speakers. The guy was just my favorite, Bendrick Maralit.
And the school that won this round?
A very, very close fight. Really, you were excellent, both of you. But just by a few points, the winner is the University of the Philippines.
A big congratulations to the University of the Philippines for winning this round. Next week, Jorge College and the University of San Jose Recoletos will face off for the final slot in the semifinals. I'm Maiki Oreta. Thank you for watching.